have a very large and very interesting panel. So I am going to attempt to keep them on track. I've told them that they only have 15 minutes to talk, and that I've got a almost time's up sign and a time's up sign to hand them. You can see why I love running things. I'm also going to introduce them all at once so that we don't have to break things up, because I want to leave some time for you to have questions. I know you're going to have them, because these folks are the people who are actually doing the work that all of us academics just talk about. We get to analyze it, we get to sit back and think about it, and they have to go and do it. So I'm very pleased to introduce our panel. From my very left, this is David Codell, who is a litigator in Los Angeles. He's counsel for the Equality California and for 12 same-sex couples who are litigating on the domestic partner legislation. He's working with the ACLU, with the Lambda Legal Defense and Education Fund, and with the National Center for Lesbian Rights. And he's also involved in the case on a right to marry in California. And on his right is John Davidson, who is the legal director of Lambda Legal Defense and Education Fund. He has been referred to as the Thurgood Marshall of the lesbian and gay rights movement. And I think that's a pretty apt nomer. Then on his right is Jennifer Pizer, who is the senior staff attorney at Lambda Legal Defense and Education Fund here in Los Angeles, the Western Regional Office. And as you may notice, there's a lot of Lambda Legal Defense and Education Fund up here. That is because it's the oldest and largest organization for lesbian and gay rights in the country, and has been doing the major part of the work in this area for many years. Jenny and John worked together at the regional office, and then John left us for New York. Okay, so he doesn't always have good judgment. Now, Jenny is working now with the National Women's Law Center, the Northwest Women's Law Center in the state of Washington. Counsel in a case involving the right to marry in Washington state. They won at the state appellate court, and the case is now in front of the Washington Supreme Court. And on her right is Evan Wolfson, who is the Executive Director of Freedom to Marry. Evan has been speaking and writing on these issues and litigating these issues for a long time. He's the author of an amazing book called Why Marriage Matters. And I'm sure he'll be talking about what is happening on the national front and across the country in terms of both the pluses and the barriers that lesbian and gay couples face. Joining us, because he is now on the road and in LA traffic, will be Assemblyperson Mark Leno, who represents part of San Francisco in the state assembly. He's one of the first openly gay men to be elected to the assembly. And he is the author of Assembly Bill 19, which is entitled Religious Freedom and Civil Marriage Protection Act, which would, of course, extend civil marriage to all same-sex couples in California. So he'll be with us. I think he will sneak in at the last minute. So I'm going to put him last just because he's not here yet. So we will move in this from David Codell to talk about Los Angeles litigation in California, to Jenny to talk about litigation in Washington state. So we move north. Then we move to the national scene with John Davidson talking about the true gay agenda, and then it doesn't have anything to do with SpongeBob SquarePants. And then to Evan, who will talk more generally about the opportunities, barriers, and the national scene. So David, take it away.
Thank you. It's an honor to be here today, and I should start by disclosing that I'm going to be discussing two sets of litigation here in California. One set of lawsuits that concerns the validity of California's domestic partnership statutes, and another set of statutes that concerns the invalidity of California's restriction on marriage that prohibits same-sex couples from marrying. And I'm counsel in that litigation with John and Jenny from Lambda Legal, with the National Center for Lesbian Rights, and with the ACLU. And in the marriage litigation with two law firms, Heller Ehrman and Steve Levitt and Weiss. Okay, I'm going to start with the domestic partnership litigation. California has one of the broadest set of statutory rights for same-sex couples that's ever been enacted. AB 205, the Domestic Partnership Rights and Responsibilities Act that went into effect on January 1st of this year, actually represents the broadest grant of rights by a legislature that wasn't court-ordered. Vermont's civil union statute, of course, was enacted in response to a court decision. Here in California, our legislature enacted this bill that grants to same-sex couples who register as domestic partners many, in fact, almost all of the state law rights that accompany marriage. A couple caveats to that. Domestic partnership in California is not limited to same-sex couples. Different sex couples, where at least one of the members is 62 years old, may also register as domestic partners so as to hold on to their Social Security benefits. But I'm going to be focusing on same-sex couples. The domestic partnership law does not affect federal law. In other words, none of the federal rights of marriage are granted to same-sex couples who register as domestic partners here in California. So we're just talking about state law rights. And there are some distinctions between the legal protections that are made available to same-sex couples and those that are available through marriage. For example, domestic partners in California still cannot file their state income taxes jointly, and there are some other differences as well. Right after this legislation was enacted in 2003, two conservative legal groups filed lawsuits challenging the Domestic Partnership Act as unconstitutional because it constituted, in their view, an amendment of a statute that had been enacted by the voters through the initiative process, Proposition 22, which was enacted in March 2000. And that measure states simply, only marriage between a man and a woman is valid or recognized in California. According to those who are challenging the domestic partnership statutes, AB 205, the new domestic partnership law, impermissibly amends Proposition 22 by essentially creating a new kind of marriage here in California. We are contesting that suit, obviously. We intervened on behalf of Equality California, a statewide gay and lesbian civil rights organization, and on behalf of 12 same-sex couples. And I think the important thing about that litigation is that that lawsuit is not really so much about the rights and responsibilities of same-sex couples and the need to grant such rights. Let me put it this way. It's not so much about the need to grant such rights to same-sex couples or whether same-sex couples are entitled to certain protections. It is instead more about the initiative preemption analysis under California law. And what did the voters mean to do when they enacted Proposition 22 in the year 2000? That measure says simply, only marriage between a man and a woman is valid or recognized in California. At the time that the voters went to the polls in March 2000, California had already established its domestic partnership registry here in California, and more important, domestic partnership registries had existed for approximately 15 years in various localities, various local governments here in California. So much of the litigation concerning the domestic partnership statutes really focuses on whether the people can be said to have intended, in enacting a law about marriage, to have also tied the hands of the legislature so as to prevent the legislature from protecting same-sex couples. To be clear, those who are challenging the domestic partnership statutes are affirmatively arguing that as a result of Proposition 22, the California legislature no longer has power to enact any protections for same-sex couples beyond those that existed on March 7, 2000. And in case you're wondering what that includes, domestic partnership in March 7, 2000 provided for domestic partners hospital visitation rights and nothing else unless you happen to be a government employee in which case certain health benefits would be available. So we're talking about an extreme restriction were the courts to accept the challenges that have been brought. We have argued that, of course, those 14 words that are contained in Proposition 22, which do not even mention domestic partnership, which don't mention even same-sex couples, could not plausibly have the meaning that those who are challenging domestic partnerships say it has. Moreover, we have some important constitutional arguments. We contend that a law that would attempt to freeze in place the legal protections that one group of families may obtain from the legislature would violate the U.S. Supreme Court's decision in Romer versus Evans. To be clear, the argument that is being made by those who are challenging the domestic partnership statutes is not that same-sex couples can't obtain legal protections. It's that they have to go through the initiative process and get those protections enacted by the electorate as a whole. That, of course, was a fundamental flaw of the law that the Supreme Court struck down in Romer versus Evans. In that case, the Colorado people had enacted through initiative a measure that prohibited any part of the government from recognizing any claim of discrimination based on sexual orientation. And the Supreme Court, in striking it down, noted that it didn't mean that that gays and lesbians could obtain no legal protections in Colorado, but it meant they had to use the initiative process, and the U.S. Supreme Court said that was impermissible. There are many other issues in that litigation, but I better turn to the marriage litigation as well. In the marriage litigation, there are in fact numerous lawsuits pending in California. They have all been consolidated coordinated into one set of proceedings in the San Francisco Superior Court. We are waiting for that Superior Court to rule any day now. The cause was fully submitted on January 14th, and the court has 90 days to issue its opinion. In California, when the judges don't issue their opinions within 90 days, they don't get paid. So we're expecting him to rule. I want to highlight some ways. There's marriage litigation going on all over the country. I want to just highlight some ways in which the litigation is a little different in California and some real advantages we have here in California as we seek the right to marry on behalf of same-sex couples. We seek this right on numerous legal theories, including equal protection challenges. We assert that the denial of the right to marry to same-sex couples is discrimination based both on sex and sexual orientation, and is furthermore irrational no matter what it's based on. And secondly, we contend that in California there is a fundamental right to marry the person of one's choice. So let me just highlight some ways in which we have some arguments available to us here in California that aren't available elsewhere. First of all, we have AB 205, the new domestic partnership statute. In that statute, the legislature grants to same-sex couples nearly all the rights of spouses under California law. And including, there's a specific provision that says, with respect to children, domestic partners will have the same rights and responsibilities as spouses. What that means is that those who are arguing that the marriage statutes, which currently discriminate, serve important governmental interests, are not able to rely on interests related to child rearing, because the legislature has determined that domestic partners have the same rights with respect to child rearing, with respect to adoption, with respect to just about anything, actually. And so there are a whole host of arguments that are typically made in these marriage cases that simply can't be made in this state. And in fact, the Attorney General of California, which is defending California's statutory ban on same-sex marriage, has refrained from making those types of arguments in these cases. He has, of course, pointed them out to the court, but is not relying on them. There's another important way in which we are benefited by the domestic partnership statutes. AB 205, thanks to some wonderful drafting that I think some people up here had something to do with, AB 205 includes some really wonderful findings by the legislature, and these findings are enacted into law. And these findings include propositions such as the fact that that gay and lesbian couples have suffered discrimination based on not only sexual orientation, but based on sex. the legislature has determined that the previous exclusion of gays and lesbian couples from the legal protections that are available basically through marriage constitutes a form of sex discrimination. That's a wonderful thing here in California, because in California, laws that discriminate based on sex are subject to the strictest level of scrutiny by the courts, more scrutiny than in the federal courts. So if the courts accept the legislature's determination that restrictions against same-sex couples, same-sex couples discriminate based on sex, then we have a much greater chance of prevailing. And wonderfully for our side, the California Supreme Court this year came out with a decision that says the legislature's findings that something constitutes sex discrimination are subject to deference by the courts. The courts should defer to the legislature's determination that something constitutes sex discrimination. Finally, I'll just highlight one other set of advantages we have here in California. The first constitutional decision by any court in this country stating that the laws that used to ban mixed-race marriages were unconstitutional was a California Supreme Court decision called Perez. And in that decision, the California Supreme Court emphasized that the right at issue is not just the right to marry someone, but the right to marry the person of one's choice. And we couldn't have hoped for a better formulation of the right that's at issue here. The right to marry the person of one's choice. The reason that's great for those who are fighting for the right to marry someone of the same sex is that typically in these cases there is an argument set forth that the right to marry by definition means the right to marry someone of the opposite sex. But that's not how the right is described in Perez. Also, in Perez, the California Supreme Court expressly rejected the notion that it was up to the legislature to fix these problems. In Perez, again, a mixed race, a case challenging the statutes banning marriage by mixed race couples, the California Supreme Court said, we have a constitutional responsibility here that we cannot simply, and here's Assemblyman Releno, we cannot simply wait for the legislature to act. If a constitutional violation is shown, the courts have a responsibility to address it. There's a lot more I could say, but we've got a large panel here, so I'll stop here, and if you have questions later, I'd be happy to discuss them.
Ready to go, okay. I'm going to ask Assemblyman Leno to go next so that we can stay in California. As I told you, remember that he is the author of the Religious Freedom and Civil Marriage Protection Act and has battled LA traffic to get to us. Assemblyman Leno.
Thank you. These are introductions we're doing, or what should I be doing? How much time?
You've got 15 minutes,
Oh,
and I'll give you
minutes.
I'll give you a 2-minute and a
You
0.
may regret that.
Uh-oh.
Nice weather you're all having. I'm sorry I'm late. When you're ready for some sunshine, come visit San Francisco.
Oh, that's cool.
So I had just walked in, and we can't wait for the legislature to act. I couldn't agree more. We have to move forward, and we are moving forward. And it's an exciting time to be in the California State Legislature, and it's an exciting time to be fighting for marriage equality. And clearly, there have been many individuals, many of them sitting beside me, who have been working for so very many, many years and laying the groundwork for us to be able to move forward with this bill at this time. So this is the second version of the bill that I have introduced. Last year it was AB 1967 and entitled the Marriage License Non-Discrimination Act. This year the number is AB 19. The title is Religious Freedom and Civil Marriage Protection Act. We have added a section, well, first of all, the core of the bill is amending Section 300 of California's Family Code, which presently defines marriage as a civil contract between a man and a woman. Our bill will amend it to be a civil contract between two persons. But we did add another section, given that we recognize the core of the opposition is coming from a religious and faith position. So to address it directly, we added a section which really just restates the obvious, First Amendment rights to freedom of religion. But we thought it was important, in fact critical, to restate it in the bill. So this new section reads roughly that no minister, priest, rabbi, or any religious institution which does not recognize nor wish to solemnize same-sex marriages will be required to do so, quite simply. And I believe that very, very sincerely. I will fight to the end to defend anyone's right to disagree with what we're doing and to disagree with what we're doing from a position of faith. And I say that as an individual of faith and, quite honestly, a rabbinical dropout. But we're also, of course, fighting for this, at the same time, for what we believe to be a constitutional guarantee of equal protection under the law and allowing every California citizen who otherwise qualifies to be able to be issued a marriage license across the desk of the county clerk. Nothing could be more bureaucratic. We'll leave the religious aspect to the religious institutions. We also added a finding in the new bill, which I think says it all, but I'll let legal scholars and lawyers and others who know better than I to determine that. But it seems pretty straightforward to a layperson such as myself. We lifted a quote from the 1948 California Supreme Court decision which ended the ban on interracial marriage. Of course, this state being the only state to end that ban prior to the 1967 Earl Warren Court decision, which finally put that to rest in this country. And in 1948, our justices stated that marriage is more than a civil contract to be regulated by state law. They said that it is a fundamental right of all citizens. I'm paraphrasing, they said free men. It is a fundamental right of all citizens. And they went further and said that any legislation infringing upon that fundamental right must be based on more than prejudice and must be free from oppressive discrimination to comply with the constitutional requirements of due process and equal protection under the law. 1948, California Supreme Court. So we are now moving forward. We're picking up steam. You may have read articles that suggest that the politics in Sacramento have been dampened as a result of the national elections on November 2nd, but none of it is true. We had 20 co-authors last year. We have 30 co-authors this year. The Speaker of the California State Assembly, Fabian Nunez, has joined me as a joint author, which is the highest level of co-authorship, literally putting his name next to mine on the cover of the bill. You can imagine that a Speaker of the Assembly doesn't do such a thing expecting the bill to lose. So we feel very confident. Now I'm not expecting the Speaker to do the lifting for us. We're doing our own work and working with our partners in this effort. Equality California, our sponsor of the bill, and of course Lambda Legal has been so extraordinarily important, as has the ACLU and the National Center for Lesbian Rights and a number of other players as well. So with 30 co-authors, we're moving forward. We probably can identify today at least 32, the magic number being the simple majority of 41 on the Assembly side, 21 on the Senate side. And the Senate battle will be much less intense. Once we get it out of the first house, the Assembly, we're very confident it will sail through the state Senate. So 32, 33 identified supporters today on the Assembly side. We won't know until the day of the vote actually who the 41st vote is, and that's just the nature of breaking new ground. It was the same way when we finally, after 22 years of effort, added the word sexual orientation to the California Fair Employment and Housing Act. Such a radical and revolutionary concept at the time. We all shrug our shoulders today, but we didn't know who the 41st vote was going to be until it passed the day that it did. And I do want to remind everybody, it took this state 22 years to add the word sexual orientation to our Fair Employment and Housing Act. The legislature did pass it, 1991, I believe it was. Governor Wilson disappointed many people and, according to some, broke his word and vetoed it. Came back again by 1999. Gray Davis signed it into law. And I give you all that historical reference because I believe legislatively here in California now We are moving at hyper speed. My first year in the Assembly, the first year that we formed an LGBT legislative caucus, we set forth to move forward 4 major LGBT civil rights bills. Not only did we get all 4 of them passed on their first try, the governor signed all 4 into law. So I think we're a bit spoiled now. I talked to some young reporters from LGBT press when I introduced the marriage bill last year, and I remember one young man asked me, why are you doing this if you don't know that it's going to pass and it's likely not going to be signed into law? Why would you do this? And I said, let me just share a little history with you. I hope I didn't say young man. These things don't always happen overnight, and that's the nature of the legislative process. But he had only seen success. He had never understood that these things actually can take many years. So we have been building here on a very strong foundation. And those who have come before me have laid out the pathway for us. And so whereas in other states, and of course we're all reminded of the more than handful of states this past November 2nd which amended their constitutions to end this debate in those states forever. But those were states which had nothing in terms of LGBT civil rights in their statutes. They had no protection from discrimination in employment and housing. They had no domestic partnership registry. They had none of the many laws that we have now in place now for some years. So we are really set to be doing this. It is appropriate that we are doing this. We would be worthy of disdain and severe criticism if we were not moving forward at this time. And I also want to credit the leadership of San Francisco and subsequently County in Oregon and New Paltz, New York, and of course the state of Massachusetts for issuing marriage licenses last year, because I can only know now with hindsight, because I had the idea to move forward with this bill in November 2003 after the Massachusetts Supreme Judicial Court decision. But I only know now, looking back, that without all of the occurrences of last year, I wouldn't have 30 co-authors today, and I wouldn't have the Speaker of the Assembly as my joint author. All of this is happening quite beautifully and with some kind of design that we're not in the power of designing ourselves. And I would like to share my own journey through this process. As an advocate for the community on this issue, I had for at least 7 years been involved and personally always felt I wanted the bottom line for myself and for my community, the rights, the benefits, the privileges, and yes, the responsibilities and obligation of marriage. But at that time, over those many years, I never thought it was worth fighting a war over a word. But what changed my mind and my heart so definitively was reading the decision of the Massachusetts Supreme Judicial Court. They said, just as the other 2 state Supreme Courts before them, which had dealt with the constitutional issue of denying marriage licenses to committed same-sex couples, that there is no constitutional basis for the discrimination. They said further that our nation's history teaches us that separate is seldom, if ever, equal. But they went a step further and said that, again, unlike Vermont, only marriage can remedy this identified discrimination. Only marriage because, they said, any parallel construct such as civil unions or domestic partnerships would, in their words, perpetuate a destructive stereotype that suggests that there's something inherently inferior and unstable about the way same-sex couples love. Now, as an out gay man for 35 years, I've been called a lot of things, many of them I couldn't say in this room. But I never thought of it in that way, disparaging the way I love. Someone else loves in a first-class way, I love in a second-class way. And at that point, I thought, I'm ready to fight a war over a word. And when you think about it, our ability to love is our very humanity. That's the one thing all of us walking this planet have in common. Irrespective of our race, religion, creed, nation of origin, language that we speak, our orientation, our gender, our ability to love, and our desire to love another human being in an intimate and committed fashion. That is who we are as human beings. So that's what we're talking about here. And to accept or relent and to say, yeah, we'll take civil unions, we'll take domestic partnerships, even if we could get all the way to the same full benefits and rights and protections as marriage, but not call it marriage, would be to continue to perpetuate that destructive stereotype. So it's a very, very important battle that we're fighting here. And from my read of history, marriage has always been a basic tenet of citizenship, first-class citizenship. Slaves were denied the right to marry. You could disparage and make an underclass merely by denying an entire group of people their right to marry, along with the right to serve honorably in one's military. Those are two basic tenets of citizenship. And of course, the LGBT community is denied both of those, and I think defines us as a second class of citizenship in this country. So we move forward. The bill, AB 19, will have its policy committee hearing in the Assembly Judiciary probably sometime in later May. Last year when we made it through that committee, we made history. Never before in this country's history had an elected body of individuals voted in favor of marriage equality. This year we'll repeat that. Every Democratic member of the Judiciary Committee on the Assembly side, which represents a majority of the committee, is a co-author of the bill. So we think we'll do well in the Judiciary Committee. It will then go to the Appropriations Committee, as it did last year, and I want you to know that Professor Sears gives a mean presentation at an Appropriations Committee, and I'm very indebted to the Williams Project for putting together the study that they did so that we could present to the Appropriations Committee last year, as we will again this year, that this will not be a drain on the general fund. It will provide revenue in the tens of millions of dollars to California, mostly through all of the many people who will be coming to California to celebrate their commitment and their devotion, their love, and their marriages. I think it was Margaret Chu who said that ice sculptures alone could balance the budget of California. So we can't imagine that it will have trouble in appropriations either. Again, every Democrat on the Appropriations Committee is either a co-author or already publicly in support of AB 19. So it will then move to the Assembly floor. And we'll be working with our sponsor and with our collaborative partners as we get closer to that floor vote. But as I already told you, it will be dramatic, it will be uncertain, but we're very hopeful that we'll be able to move it then to the Senate side. And speaking with Senator Sheila Kuehl, she envisions not only 21 votes on the Senate side, which is the simple majority, but we could be close to 22 or 23 out of the 25 Democrats there. And without making any presumptions of partisanship in this room, I want to be respectful. This is not a partisan issue. There is no reason why our Republican colleagues should be joining us in supporting this. In fact, there have been many very strong arguments from a conservative and Republican perspective as to why this is a conservative core value: stability, commitment, devotion, marriage, and family. So thank you for letting me join you here today. It's a pleasure to talk about this.
We obviously have the inside track on what's happening in the courts and in the legislature in California. Now we'll turn to Jenny Pizer for some insight in what's happening in the courts in Washington State.
Yeah, it's really a pretty amazing time. I mean, what Mark was saying about how things have snowballed from a place that was where there was not much we could do in Sacramento to what it's like now. It's just incredibly inspiring. So I want to start by saying that working on this marriage case in Washington State and the marriage work we're doing all over the place has really illustrated for me not just what the marriage work is about, but how much our community is developing incredibly powerful, wonderful ideas about family. And so I want to start by thanking my partner, Darina, who's sitting over there. We've been together for 20 years, and
That's an accomplishment, no matter what.
and thanks to who she is in my life, this work is never abstract to me. It's never theoretical. Transitioning from law firm practice to working in public interest law, we all learn about for richer, for poorer. And as we, think about some of the victories we've had this past year, and we think about the elections, we've also learned about for better and for worse. But it's really, we're making incredible progress, and the fact that we're bringing our community, the clients that we represent, and the work that all of us are doing every day to just be ourselves in society is why we are having more success, because these cases really are about families of people who love each other, and then the legal theory kind of comes along after. Now, I had to start by saying that because I now want to introduce one of my co-counsel in this case, Jennifer Devine, who's sitting up in the back, because we've actually been very close friends and really family for 25 years. We were college roommates, and we, in college, both became lesbians separately. And then sometime later, we both decided to be lawyers separately. And then I think it's fair to say that both later in our lives, after doing an awful lot of feminist work, and it's just kind of interesting that both for separate paths, we both become very committed to the idea of marriage equality, why it's incredibly important that we win marriage. She is critically important for why Lambda Legal has been involved in the litigation with the Northwest Women's Law Center. And I want to say that in front of all of you as witnesses, she's personally responsible for some of the best aspects of that case. The case was filed about a year ago, in fact, March 8th, when the oral argument will be held in front of the Washington Supreme Court. It will be 1 year exactly to the day of when we filed the case. This has been the most amazingly fast and intense year of litigation. And sort of, for me, a crash course in learning about Washington law and politics and things. So I'm relieved that she's here because she's never been hesitant to correct me, and so that may be a good thing for all of you. But I am relieved that her daughter is not here. I'm really relieved because she really never hesitates to correct me. So the case was filed about a year ago, and you'll recall that that was the time when the San Francisco marriage explosion had happened, and there were licenses being issued in New York and in New Mexico, and of course, couples had been marrying in Canada for some period of time. And in Seattle, there was an elected official who was running for governor who was getting some pressure. He was the head of the county government in King County, which is where Seattle is. He was facing pressure to issue licenses, and he decided that it was actually a no-lose position for him to be in to invite some folks to sue him. And I think actually that tells us something important about the progress we've made, because he wanted to be able to express in a tangible way his support, which is really great. But he also wanted to sort of present himself as someone who would uphold the law, because after all, he thought it might be nice to be governor. And so that really was the catalyst for the lawsuit. There actually were two different suits that were framed up to be complementary. The suit that we've been involved in represents a group of couples in King County And the idea there was that, of course, we were suing the official who was voicing his public support, so that was kind of a good thing. But also, that's the most progressive part of the state. There's an enormous gay and lesbian community and a range of protective legislation at the municipal level. So that seemed like the place where there was the greatest likelihood of getting a good result, if not at trial, then through that particular court of appeal. But then there was a second case put together that was litigated by the ACLU that represents a group of couples statewide, making a real point about having statewide diversity among the plaintiff couples. And that suit also took on, Washington has a state DOMA that concerns marriages within the state and also marriages from outside the state. So our case just focused on the in-state ban. The other suit concerned the in-state ban, but also couples who had been married in other jurisdictions, specifically Canada, of which there are quite a few in Washington who had just gone across the border, married in British Columbia, come back. And so that suit had some other issues, and they were thought of as complementary in ways to sort of hedge our bets and try some different things at the same time. Now, from the beginning, the litigation was on a sprint for a number of different reasons, including the intense energy going on in the country, but also because there was a member of the Washington Supreme Court who was due to retire at the end of the year. And while people don't usually think of a case of this kind of magnitude as going from filing the complaint to the Supreme Court in about 6 months, that was what we were actually attempting to do. And we didn't exactly get that to happen, but it has been on a pace that's really been just a blizzard. It's just been amazing. A couple of features of this the litigation that are sort of distinctive. One is that from the beginning we faced a motion to intervene from some right-wing folks. Well, that's not unique. They seem to be showing up every time we turn around in California. But in the Seattle litigation, the judge appeared to be a bit concerned that the county official and his office that was charged to defend the marriage statute had appeared at our opening press conference saying that he really hoped that we would win. And that was a lovely moment, and there were some wonderful photo ops that I think were probably very helpful to sort of public receptivity to things, and I don't think it hurt that he's an African-American minister as well as being the county official, so his presence and his support communicated a whole lot of good things all at once. But it also communicated to the judge that perhaps the people under his direction wouldn't defend the law as zealously as is supposed to do, and so he let the interveners in. Now, the interveners, and this is something we've certainly been dealing with in California as well, promised to make things a bit more complicated, not always to be so cooperative about case scheduling and so forth. There's a silver lining, or at least it looks like one now. We'll see what happens in the long run, but so far it seems like there's been a silver lining, that they have seemed to be kind of a physical embodiment of the folks that worked to get the state DOMA passed in 1997. And so in some of the states, you know, you face this argument of, well, this marriage law was passed a long time ago. Nobody was thinking about excluding gay people. No one was thinking about gay people when that happened. Well, in Washington, you know, for better or worse, there were hearings. There was a lot of testimony. They weren't very nice. There was a lot of religious testimony. There was a lot of discussion about what kids need and what social science may or may not say. I mean, all kinds of junk in the legislative record. Well, these guys, at least it seems helpfully, packaged some of that stuff up, brought it right into court, and acted really obnoxious and not nice and irrational. And so there was sort of this demonstration right there for the judge, in case he needed it, of what really is behind the passage of that kind of law. And of course, there's legal theories that make that relevant. So it was kind of helpful. Now, if the judge hadn't been pretty smart, you know, maybe that he wouldn't, our trial judge wouldn't have been able to sort through the stuff and make good use of it. But we did have a very good judge. His reputation was such that we didn't really know what he was going to do with the case. He had a reputation of being responsible and smart and sort of taking very seriously his role as a jurist, but we really didn't know what to expect from him. What we got from him, and this was a decision that was that came out in August, was a terrific decision, and you know, not just from being close to it, but I do think I would recommend to folks. It's posted on our website. It's easy to find. It's a really terrific decision. It's not just that he applied the legal theories as we thought he should, but he made a couple of points that are really what this case, what this type of litigation is about. First of all, he talked about how the plaintiff couples and their families are role models. He debunked the idea that they were somehow not representative because they'd been handpicked. Of course they were handpicked. But he took the right message from it, which is these are wonderful families. And yes, they're role models. And he talked about how all of us should be pleased to sit next to them in the little desks at back to school night because they're wonderful people. And that, of course, is true, and that was the point. And he also talked about if there's any threat at all to the institution of marriage, it's not from couples like these. It's from, he said, an excess of selfishness, people not living up to their commitments, not from committed same-sex couples who want to take those vows to each other. They're not aiming to go into anybody else's marriage or anybody else's home. It's about the families that exist. Yeah, those are the things we know they're true, but he said it in a pretty great way, and that was, as far as I can remember, the first time there was a trial court that had said that sort of thing. There have been some terrific appellate decisions, but the trial courts often feel that their hands are kind of tied and they're not really supposed to go out on a limb, and his opinion was terrific. Well, there's nothing like competition sometimes, and so it does seem like the decision that came out about 10 days later in the other case from a different county, there was a little, okay, well, so you said that, I'll give you that, plus I'll give you strict scrutiny. Which was tremendous, and it was quite helpful that decision came from the county that people would see as being less progressive than Seattle. So here we had two really good, detailed, emphatic, positive trial court decisions, and they go up on appeal as a package. Very strong posture for appeal. There was, of course, a certain amount of backlash from having a couple of good decisions. Of course, if anybody rules in favor of an LGBT person, then they must be a judicial activist. And there has been some of that. And there have been some very large rallies of large churches making angry noises. And it is kind of intimidating to see that they can turn out thousands and thousands of people to a stadium. But there's been an education and organizing movement in Washington and in King County in particular for years, and there's a lot of awareness and support. I want to highlight just a couple of things about the Supreme Court and sort of key themes that we've been developing in the briefing for the Supreme Court. Okay, and I'm going to do it in 2 minutes. There's 9 members on the court. 2 of them, one's a libertarian who is has been clear about, he's libertarian but maybe not for gay people. And then there's a newly elected justice who's extremely conservative and noisy about it. But most of the members of the court have a reputation for being kind of centrist. A couple of them are progressive, but there's enough people that are in the middle that are believed to have an open mind. Not that there's anything to be taken for granted at all, but the consensus seems to be that we have a shot. It's certainly not a foregone conclusion. Probably there is a majority that will recognize there's a constitutional violation. Whether they will say that the remedy for that should be equality, should be marriage, remains to be seen. Since we kind of knew that was a thing we needed to focus on, the array of amici briefs that were put together, and I'll sort of focus in the limited time on what I'm calling the amici scorecard, which I think is pretty fabulous. Sort of the main statistics, 15 on our side, 7 for them. Most of the ones on our side, with just a couple of exceptions, are from in-state organizations, and the lawyers on those briefs represent all of the major law firms in the state, or at least most of them. On the other side, most of the groups are out of state, written and prepared out of state, with local folks not being particularly prominent. On our briefs, the whole cover, the back cover, the middle are just, there's an immense number of co-signers on them. and on the other side, not the case. On our side, we have an enormous support from religious groups, and on the other side, there's no churches at all. And the two things that I'll close with in terms of what I think are sort of key things that are communicated to the court by this array of amici briefs. There's an immense support from labor. There are business groups. There are civil rights leaders, not organizations, not national civil rights organizations that sort of represent national politics, but individually named civil rights leaders in the state. And leadership from academics and relevant fields of social science. So that if you look at the array, it's not just that it's enormous, but it's mainstream. It's broad and deep, and it represents the state. And that, of course, was what we were trying to convey.
I remember at the first Williams Project Symposium on Sexual Orientation Law, the question being asked how long it would be before marriage between same-sex couples would be a reality in the United States. Some said 50 years, a significant proportion of those present said 20 years, a number said 10, and a few of the most very optimistic said it could be 5 years. But I don't think any among us honestly believed that fully legal marriage between same-sex couples would exist in the United States in fewer than 4 years. Clearly, the most momentous development of the last year is that there are now thousands of legally married same-sex couples in the United States, and not just couples married on foreign soil, but Americans married here in the U.S. For 9 months, same-sex couples have been able to enter legal marriages in Massachusetts. Approximately 5,000 such marriages have taken place, meaning that there are 10,000 lesbians and gay men who were and are legally married to their same-sex spouses here in this nation. Contrary to the shrill, apocalyptic warnings of the far right, civilization has not ended. Massachusetts has not fallen into the ocean. Indeed, it hasn't even been hit by hurricanes, earthquakes, or locusts. Sometimes, though, I think that maybe we may be misunderstanding the fundamentalist right's doomsaying when they say society as we know it will come to an end if same-sex couples are allowed to marry. Maybe they're right. Society as they know it, a society that treats some people as less than full and equal members of our country and that discriminates against, marginalizes, seeks to render silent and invisible, if not converted or dead, and scapegoats gay people in our families, is something we are close to having come to an end. 2004 was the beginning of this new society. What's been most interesting in terms of the press coverage, I think, is how uncovered the lack of problems in Massachusetts has been. It's been a total non-story. But that itself should be the story. Men and women have not stopped marrying one another in Massachusetts. There have not been a rash of divorces of same-sex couples. Indeed, Massachusetts is the state with the lowest divorce rate in the nation. All that has happened is that thousands of same-sex couples and their children in that state now have more legal rights and responsibilities, are more protected against tough times and crises, and are enjoying a measure of equality previously unknown to gay people in this country. The progress forward has not been limited to Massachusetts. You've heard some about the implementation of AB 205, California's far-reaching domestic partnership law, and about the good chances of success of the California marriage litigation and of AB 19, Assemblymember Leno's critically important marriage bill. You've heard about the success in the court so far in Washington state. Besides being co-counsel in the cases in California and Washington, Lambda also has a case in New York State, Hernandez versus Robles, in which the trial court ruled February 4th that it violates the equality and liberty rights provided under the New York Constitution to deny same-sex couples the freedom to marry. And we have a case in New Jersey, Lewis versus Harris, which was argued to the Intermediate Appellate Court in that state on December 17th, and in which we're awaiting a ruling. The ACLU, besides its case in Oregon, also has a case moving forward in Maryland courts. Gay and Lesbian Advocates and Defenders, which won the Baker case that resulted in civil unions in Vermont, and won the Goodrich case that brought us full marriage in Massachusetts, has a case moving forward in Connecticut courts, and recently had its challenge to the law in Massachusetts that's been used to block non-resident same-sex couples from marrying in that state, accepted for review by that state's high court. And the National Center for Lesbian Rights, besides being lead counsel in the California marriage litigation, has a case pending in the Florida courts. So from a little more than a year ago, where there was one affirmative marriage case pending in New Jersey, we now have it moving forward in 8 states. And besides the marriage equality bill in California, there have been similar proposals made in Connecticut, Maine, and Rhode Island. So whatever some may think about the wisdom of San Francisco Mayor Gavin Newsom's decision to allow same-sex couples to get married in San Francisco a year ago, no one can deny that it jump-started the movement forward for marriage equality like nothing else anyone could have imagined. Clearly, there have been some losses. Cases that a number of the national LGBT organizations tried to discourage from being pursued unfortunately resulted in the decisions we feared in Arizona, Indiana, and federal court in Florida. But each of those cases is now over, with the parties to them ultimately having decided, quite wisely, I think, not to pursue them any further. Part of the challenge we face right now is being smart in choosing our battles, and in particular where, especially when, and how to bring them, informed by the accumulated wisdom garnered from past litigation and backed by the considerable resources those battles require. And of course, there have been horrific state constitutional amendments adopted over the last year, and those will continue to be urged over the years to come. But I believe the movement forward actually has been dwarfing these backward steps, because our opponents largely have targeted states where we were unlikely to see quick progress in the courts or legislatures anyway. Progress has been made not only regarding marriage, but with regard to other means of securing at least some protections for lesbian and gay couples and their families. We now have statewide legislation providing numerous rights to those in same-sex relationships in California, Vermont, New Jersey, Hawaii, Maine, and the District of Columbia. If you ever catch yourself feeling dispirited about the opposition we face, just think about that for a minute. Equal marriage rights in Massachusetts, and extensive rights for same-sex couples in 5 other states in the District of Columbia. Would anyone really have thought we would have moved that far in just a few short years? In addition, in Lambda's Langan versus St. Vincent's Hospital case in New York, a man who entered a civil union with his long-term partner in Vermont has been allowed to sue for the wrongful death of his spouse by relying on New York comedy principles that honor the spousal relationships lawfully entered in other states. In a case that's still going on, thus far at least, a lesbian couple who entered a civil union in Vermont have been allowed to dissolve that relationship in the Iowa courts. Battle Royal is now moving forward in both the Virginia and Vermont courts in the Miller-Jenkins case that Lambda is handling regarding the custody of a child born in Vermont to a couple who had entered a civil union there. And in addition to the thus far successful defense of AB 205 that David talked about, Lambda so far successfully has defended domestic partnership benefits afforded New Orleans city employees in a challenge brought by right-wing groups in Louisiana. And earlier this year, the ACLU won domestic partnership benefits for employees of the University of Montana in the Snetzinger case. When you think about the fact that 30 years ago, the concept of domestic partnerships and civil unions did not even exist, the progress we have made, and a lot of it just this year, has been unprecedented and phenomenal. I want to use the rest of my time to talk with you about why I think it is that we've had greater success in the courts than in the legislatures or in public opinion, although it's essential to recognize that we have had important successes in forward movement in all 3 venues. I think few will dispute, however, that the win ratio in the judicial branch on marriage and other same-sex relationship issues has been the highest. If you look at the court victories we've had, from Hawaii to Alaska, Vermont, Massachusetts, Washington, and New York, in all those cases we secured movingly eloquent and sweeping judicial affirmations of equality and liberty for lesbian and gay couples. Well, how is it that we've been able to do so well in the courts? I think there are 4 principal reasons. First, we've been using the right building blocks and choosing the right battles. One of the remarkable things about reading the New York Hernandez opinion is seeing over and over how it builds on the victories we secured in the past. Not just Lawrence and Romer and Goodridge, but cases like Braschi that Bill Rubenstein argued and won, and in Nofri, a case from years ago in striking down the sodomy law in New York, and Levin versus Yeshiva University, an important case that the ACLU brought, matter of Jacob and Langan, and case after case that they used to build to this victory. Victories do not spring forth fully formed from Zeus's brow. They are built on foundations carefully developed over time before open-minded and receptive courts based on good facts, helpful precedents, and a politically viable climate. So that's the first reason for success. Second, in court we are able to force deeper thinking, particularly about core fundamental rights and values. Unlike asking someone their view in a public opinion poll, courts are supposed to do much more than give quick, unthinking responses. They're supposed to come to their decisions after full engagement, after lengthy and careful consideration of the issues and the arguments. They read pages and pages of briefs from the parties and from amici. They review case law. They listen to hours of argument where the other side's positions are able to be responded to fully and where there is real intellectual give and take and not just sound bites. Beyond that, the question posed to them is not, do you approve of the outcome of same-sex couples being able to marry, but what do our deepest values of equal protection and personal liberty really mean and require when it comes to this issue? What is it that the noblest and most important principles that underlie this nation tell us is the right answer, as opposed to the popular or easy one? Third, in court, we're able to focus on the legal rather than the religious institution of marriage. When we're in court, it's undisputable that we're only talking about the civil institution of marriage, what government grants. But when people are asked by the polls, should same-sex couples be able to marry, it's unclear if they're thinking about legal marriage or religious marriage, or likely some jumbled up notion of the two. Indeed, that confusion deliberately has been fed by political and religious leaders. For example, every single speech that President Bush has given about this subject has talked about the sacred institution of marriage and about the sanctity of marriage. But the sacred institution of marriage is not the legal one that results from the signing of a marriage license and decides whether you get higher Social Security benefits or not when your life partner dies, or whether you're entitled to or have to pay support if you and your partner split up. Sacraments are things afforded by religions, not governments. And government doesn't sanctify anything. That, again, is a religious concept. Clearly, there has been a concerted attempt to confuse legal rights, R-A-G-H-T-S, with religious rights, R-I-T-E-S. The separation of church and state means that we've been able to avoid that from happening when we've been in court. Finally, judicial independence. Over time, lesbian and gay rights have done less well in the political arena than in the courts generally. Some heterosexuals and some closeted lesbian and gay officials historically have been unwilling to speak up for gay rights for fear that doing so will brand them as gay or lesbian. In the political arena, there frequently has been an overestimate of the cost of supporting gay rights. There also is an organized and well-financed wrathful opposition to deal with that in many parts of the country, including at the national levels, controls or significantly influences the Republican Party and many Democrats as well. But I think it's also important to recognize that the assault that we have seen on our progress at the ballot box in some states is not unprecedented. For those of you who are older, you may remember back to 1964, when California passed Proposition 14, an attempt to undo fair housing protections by supposedly giving homeowners a state constitutional right to choose who they wanted to rent to and who they didn't. That initiative was the result of organized political opposition to racial equality gains that had been won largely in the courts. Similar measures passed in numerous places in the country, and what it ultimately took was the federal courts stepping up to the plate and striking down those constitutional amendments in cases like Reitman versus Mulkey and Hunter versus Erickson on federal constitutional grounds. And today, having won these battles, society is at a place that looks back in surprise at the notion that laws banning race discrimination in housing once were highly controversial. For those of you who are not quite as old, we saw a similar development with regard to progress we were making in the adoption of laws and ordinances banning sexual orientation discrimination in employment. Challenging our victories, the right moved the issue to the ballot box, culminating in the passage of Amendment 2 in Colorado in 1992, and attempts to do the same thing in numerous other jurisdictions. What it took was the victory we secured before the U.S. Supreme Court in 1996 in Romer versus Evan that such state constitutional amendments violated the federal Constitution, to end the right attempt to bring to the ballot box and use public sentiment to defeat civil rights progress off the table as a means of halting our movement forward. And the result has been that we now have 16 states and the District of Columbia that prohibit discrimination based on sexual orientation, with Illinois having joined the list this year and Washington being on the verge of doing so next. Now, all that does not mean that we should be rushing to federal court to challenge these state constitutional amendments or to try now to secure a ruling establishing a federal constitutional right to marry the persons of one's choice. We need to look back at why we've been successful so far and learn from those lessons. Even though state constitutional victories may be more vulnerable, as Justice Amistoy described, securing state constitutional victories in state courts is a critical building block. We saw that in the many year-long effort to eliminate sodomy laws that ultimately were held to violate the federal constitution in Lawrence v. Texas after numerous victories in state courts under state constitutions. Beyond that, having same-sex married couples in more than one state, with time for people to see and feel for themselves that nothing bad results, and that the outcome is a positive good for same-sex couples, their children, and society as whole, is a necessary prerequisite before we rush into the federal courts. Our nation needs longer to think about these issues in a deeper way, just as the courts have. We need to make the education happen, and these carefully chosen and carefully litigated state courts cases are a part of bringing that about. We need to educate people further about the distinctions between civil and religious marriage, and we need to maintain judicial independence. Indeed, the biggest peril I think we are facing right now is an organized assault on the courts, led by attacks on them doing their job of protecting our constitutional rights as somehow illicit judicial activism, and by threats to recall judges whose decisions right-wing organizations do not like, and perhaps most frighteningly, by attempts to do away with the filibuster rule in Congress in order to jam the federal courts with arch-conservative Bush appointees. Lambda is commencing a new project entitled Courting Justice that I hope you'll all be hearing about in the near future. The courts historically have been the ultimate protectors of civil rights in our nation, and that's what they need to continue to be, as they help teach the rest of our nation what commitment to fundamental values that are embodied in our Constitution truly mean. We are making truly incredible progress nationally in the fight for marriage equality, but we must not lose the courts in helping that progress work its way to fruition. And so I urge you to take interest in these judicial battles to come, particularly at the U.S. Supreme Court level, because I think that the strength and independence of our courts will be key to having the momentum we've seen this year bring us to the day when the main problem about a same-sex couple getting married will be trying to figure out what wedding present to bring. So here's for the 2014 Williams Project Symposium being sponsored by Crate and Barrel.
Thank you, John. It's now up to Evan Wolfson, who has often been in the cleanup batter position, to bring us home and to widen our scope. Evan.
Well, thank you. I feel lucky to be in that position, first of all, because I get to thank the Williams Project for the terrific work that has been done, and you've heard a lot about that today, and particularly the exploration and making real and concrete how the exclusion from marriage harms our families and harms our communities and government and our society by depriving people of the opportunity to participate equally. This has been a very valuable contribution to this national debate and the state-by-state debate. And it also gives me a chance to express my gratitude and love for the people sharing this podium today. I mean, we have terrific advocates and voices like Chris, like David, my dear friends and colleagues, Jenny and John, and Lambda Legal, which has done such amazing work. And today, to especially acknowledge the courage and leadership of Mark Leno. Mark Leno's introducing this bill, not 1 year, but 2, and his, as you've seen, extraordinarily eloquent and persistent championing of it, both publicly and in the corridors of power, are not only very important for us in the nation and in California, but are also, you have to appreciate, somewhat unusual. To have an openly gay legislator willing to say the word marriage and to claim the word marriage and everything that goes with it, and to insist and believe that we can make this happen, and to be leading the fight that is going to make it happen in California, over not just the tremendous opposition and ferocious attacks and resistance of the opponents of equality, the forces that we are all truly combating, but I would venture to say what may even be more difficult and painful for somebody in Assemblymember Leno's position, the timidity and underreaching of some of our so-called friends, some of our allies, some of the moderates, some of the well-meaning but challenging people that we need to call upon, who have made it very difficult sometimes for people in Mark's position to step forward and lead. For Mark Leno to be able to step forward and deal with that internal stuff, the stuff on our side, the moving the people closest to us, and to keep his eye on the prize is something really unique, and we all owe him a great debt of thanks. You have only to read the newspapers or look at the articles on Freedom to Marry's site today to look at other battles in state legislatures around the country and see the position adopted by other legislators and where they have set their sights and what they have reached for, and contrast that with what we have going here in California to appreciate how valuable it is to have that kind of leadership. And the other thing that's great about getting to go last is I get to quickly elide over many of the points that my colleagues have already made, and to urge you, and I wouldn't ordinarily do this, but to read the materials where I have a speech there that lays out some points that I really do believe people here need to have. And it's very short, and they are the concepts of winning trumping losses, what it means to, if you have to lose, at least lose forward, what it takes to move the middle, the two truths they need to hear, and the secret weapon we have on our side. And I'll leave you with that tease so that you'll go and read it. And instead, I get to depart from my usual role of the guy who does the rah-rah and the big picture, and as a New Yorker, I get to come here and put you to work. You've spent the day learning stuff, hearing from experts, exploring academic insights, as well as hearing from the front lines. And I'm here as an outsider to say that not only is this the year in which we can achieve marriage equality in California, but this is the place where it has to happen. It has to happen because California's families, committed couples, us, our loved ones, our children, the people who depend on us in life's family networks, are harmed by the exclusion from marriage. It matters for those people. It matters for California as a community and as a society, as the Williams Project data and as others have made clear. But it also matters because you've all heard the saying, from those to whom much is given, much is expected. California is a state that the rest of us in the country look to and depend on to lead. California, unlike some of these 11 states that we've heard so much hype about, California, unlike those states, has an extraordinary abundance of infrastructure and resources and teamwork and organizations and talent and leadership in great number. You've made extraordinary gains already. You are the ones who have it within your reach, led by Mark and others, to bring marriage home here in this state. And it's not only important for you, but it's important for our civil rights movement. It's important for the rest of the country. It's important for us as we all fulfill our duty to come back to the valiant people living and working in those 11 states and others, that we bring the wave to them from a place like California. And so I want to talk with you about what it is I believe you need to be doing here. And when I say you, I don't just mean leaders like Assemblymember Leno and the political forces we look to do the work. And I don't just mean lawyers, because they know how to do what they're doing. And I don't just mean organizations like Lambda Legal and National Center for Lesbian Rights and the statewide group here, Equality California, whom people need to link up with and work the political process. But I also mean each and every one of us, each and every one of you as individuals, because each one of us has to make a personal commitment to do our part this year to shape history. The courts are moving forward. Assemblymember Leno's bill is moving forward. We are hopeful that if they hear from you and the people the groups mobilize and the people you reach out to contact legislators, that that bill is going to go out of the legislature and come to the governor's desk. As an outsider, let me tell you that if it stopped there, you would have done a tremendous service to this national dialogue and national forward movement. Because to have the legislature of this largest state enact this measure to end marriage discrimination would send a powerful message to the rest of the country. But it doesn't have to stop there, because when it leaves the legislature, it goes to Governor Schwarzenegger's desk. There is nothing that would be more transformative to our civil rights movement, building on the stratospheric accomplishments of last year, the making it real, the putting marriages before people to see families helped and no one hurt, that opens hearts and minds, something we achieved last year. There is nothing that would be more transformative in taking our political movement to its next stage than having this largest state, through its democratically elected assembly, enacting a bill to remove the different sex exclusion from marriage and have it signed into law by that governor. This is something that you can make happen. But now is the time to mobilize like never before, to let calls and letters and visits go forward to the legislators, and in partnership with groups like Equality California, to be contacting the governor's office to make it clear that he can be a voice of forward movement and bring this state and this country, and for those who care about this, his party, to a place where he believes it needs to be. You have this within your reach to do this. This can be the year that we win marriage in California and transform this civil rights movement and our nation yet again. But if that were not enough of a reason to act, there is still another one. And that is, alongside this affirmative work that lies before us today in California, you are under attack. You are confronted by a threat. There will be a ballot measure aimed at not only blocking marriage, but taking away the hard-won gains that you have achieved in this state. We don't yet know what form it will take. We don't know whether it will simply be an effort to undo the Leno bill, should it go through the Assembly and get signed, or whether it will be a measure to undo the partnership law as well as marriage, what you have already won and what you stand to win, or even worse than that, possibly a constitutional amendment, an effort to cement our second-class citizenship in California, roll back the gains, and bar the door for a generation to come. We don't know yet which one of those it will be, but I don't have to tell you about ballot measures in California. It's coming. So if not for the affirmative reasons, for that threat, a threat that is visible on the horizon, now is the time to understand that we are in a campaign. And every day we are not campaigning is a day that we have lost the time, that we are squandering the opportunity to make our campaign go forward. It's here. It's happening. And the question you, as Californians, as members of organizations, gay or non-gay, need to be asking each and every one of them is, where is our campaign? What can I be doing today? Where do I write the check? What are you doing to work with the others to build the coalition, to bring this forward? And most important, what are you doing? What are we doing? Where's our campaign to move the middle? Now, as John said, the single thing that most moves the middle is the making it real. Vermont, Chief Justice Amestoy gave a partial, and I would agree with some of what he had to say and disagree with some of what he had to say, but he gave a partial picture of what happened in Vermont. It's true that after Vermont's legislature enacted civil union, there were legislators who lost their seat, there was an attack, there was a reaction. Contrast that with Massachusetts. Last year in Massachusetts, every single legislator who voted to oppose the anti-gay, anti-marriage amendment, proposed amendment, every single one who voted to oppose that amendment, who voted right, was reelected. And some of the legislators who voted to take marriage away, to enact an anti-gay amendment, lost their seats to pro-marriage challengers. In Massachusetts, the people have accepted the reality because they've had a chance to see it for real. In California, you have the chance to defeat the attack that's coming by giving people a chance to see the reality and not vote in the abstract, not vote on a hypothetical, not vote out of fear, but by seeing the faces and couples, not just through the wonder of what we saw last year in San Francisco, but through the powerful and deep reality of actual marriage. And do they really want to take it away? We learned two things that make the critical difference from the ballot measures and attacks of last year. And I can sum it up in what sounds like just a cliche. Too little, too late. If you give people too little and do it too late, we cannot win this dialogue with the middle. Too little means we have to give them what they need, and that's the information, the faces and voices of the real families harmed, the couples and their kids, and the non-gay people who care about them and who care about what kind of country we have. We have to say the words. We have to use the vocabulary. We have to make our own personal ask and give people the information they need to push past their discomfort and their preferring not to talk about it and rise to fairness. Too late speaks for itself. People need time to push through discomfort. People need time to take in information, to be asked, if necessary, not just once, but 5 times. But you can't ask people 5 times if you don't ask them once. Don't let California be the victim of too little, too late. And don't leave it only to others, wonderful organizations, heroic leaders, to be the ones to engage this campaign. The stakes are too high for our country, for California, for us, and the people we love. We are winning this civil rights engagement. The right wing knows we're winning. That's why they're so desperate to shut this discussion down. That's why they want people to believe that these 11 states said something about where the country is, as if Mississippi and Utah should be the barometer of our civil rights possibilities in the United States. And don't get me wrong, there were great people working and achieving things in Utah and Mississippi too, and we're coming back to work with them as well, because this is a national movement, as any civil rights movement is. But California has the opportunity to bring our country to what we want it to be. And that work depends on each and every one of us literally going home, picking up the phone, writing an email, contacting the organizations, the people, the leaders you know, and saying, where's the campaign? What can I do to help? Put me to work. And while waiting for the phone to ring back or the email to come back from them, do your part. Ask others to understand why it matters that this discrimination come to an end. And if we do that here in California, as in the country, we will win marriage equality and large possibilities and the kind of country we really want this to be.